Justice, people say, justice, justice, brother say.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Okay, I'm going to sit and wait for you to say something. So I'm not going to say anything.
Hey, this is Michael Bryan. I'm Linda Kenny Bond. We have had a very busy, you won't believe it, 20 minutes, and we're just kind of making it for you. Hello, everybody who's going to be on the chat here, because we just had an interview with, and I know I just teased it on X, Twitter, on Instagram, on Facebook, with Doug Weinstein, as I call him, the great attorney for Yak Gotti. But Michael, there's a lot more going on. And why don't you set up what happened today in the courtroom that led us here to today with this question and answer we told you that we may have, we may not have, we're having.
Yeah, I mean, didn't we just do something yesterday? I haven't had time to miss you yet. So, and I was so excited to talk with Doug because, like most people, we're going through, YSL withdrawal because they cut the cord on Wednesday last week. And everybody's speculating what's going to happen, who's doing what to whom, and some people don't know what the hell they're talking about, some do. So we got the real skinny, and we'll get to that in a couple of seconds. But we want to set up what happened today that led to, as everybody knows, I'm sure there was a plea deal today for one of the defendants, Quay, I like to call him, because I can't keep all of the other names straight. And of course, Quay was the arguable target of the post, which said "Free Quay," which should never have been read in open court. The screen version had been redacted, so the jury would not see that. But the handwritten paper they gave the witness said it, and the attorney Hilton kept prodding. Well, is there a hashtag after that? Is there a hashtag after that? And so, of course, he reads "Free Quay," and oh boy! So that leads to the 5 days of figuring out what the hell is going to happen here. So the first thing I want to look at and that we want to share here is basically, and this is very educational in terms of the big picture with this case, which has become at the very least a ball of confusion, right? I mean, we're talking about 11, almost a full year of trial, not counting 10 months of jury selection. The trial starts with the jury selection. So almost 2 years. But in terms of evidence being presented, a full year. And a lot of people are like, I don't know what they're trying to do here. I don't know what the storyline is. I'm not even sure what the different crimes are. So what we'll hear from Attorney Hilton is a recitation of the claims and the indictment charges against Quay, and then explaining which one he has pled to. That'll be, as soon as I can get it here, that'll be the first thing that we talk about. And that's key because just kind of, we start to get a roadmap, which I think we definitely need in this particular case. So stand by here. Again, this is Ms. Hilton setting up this plea deal for us today.
You understand that in this indictment, you were initially charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years. You were also charged with count 49 in this indictment, which is murder, which carries a sentence of life. You were charged with 2 counts of participation in criminal street gang activity, which was counts 50 and 51, which each carried a sentence of 5 to 20 years. You were initially charged with counts 53 and 65, possession of a firearm by a convicted felon under Code Section 16-11-133, which each carry a sentence of 15 years consecutive to count 1. And then you were also charged with count 54, which is possession of a firearm during the commission of a felony, which carried a sentence of 5 years consecutive to count 1. Do you understand that is what you were initially charged with?
Yes.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court as to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, a sentence of 20 years to serve 7 years in custody, balance on probation.
Yes.
Do you understand that as a part of the negotiated agreement, the state will null, or dismiss count 49, which is the murder count, count 50, 51, which are the gang activity counts, count 53, possession of a firearm by a convicted felon, count 54, possession of a firearm during the commission of a felony, and count 65, possession of a firearm by a convicted felon. Do you understand that is the negotiated agreement?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
And the court can sentence you to the maximum on each charge and can run those charges consecutively or one after the other.
Yes.
Well, there's only one charge that
So
a guilty plea is
I
being
wish-
entered into, so
Under my breath to that.
there's no other sentence to run anything consecutively with
Right.
regard to this plea. You understand that?
Yes.
Okay.
Yeah, Attorney Hilton there got carried away with charges versus charge because it's really only one. So, Linda, on its face, what's your take on the deal?
Okay, so the deal. Well, let me start by saying something that Doug Weinstein asked us to talk to you all about, and that is the ethical duties of an attorney. If a plea offer is made by the state, by the prosecutor, by the federal government, whoever it is, no matter what it is, if you hate it, if you despise it, if you don't think your client should take it, you have to take it to your client and say, this was the plea offer that's made, and it's one of the few things that a client has control over in a trial. The client has control over whether there's a jury trial. The client has a control over whether they plead not guilty or guilty, and the client has a control over whether they testify, and the client has a control over whether or not they accept a plea deal. It's actually those four things that the client can make a decision on. So apparently there was an offer. It was negotiated as far as we know, and this is the deal that the client decided was best for him with his 3 kids, his wife, and the fact that it's a minimum of 7 years, up to 20, but 13 of it will be on probation. And he's already been in jail for what?
300 some days, 309, I think. So
yeah. So a number of days, and he'll probably get credits for time served, good time, and all that type of stuff. Plus, he gets moved from Rice to prison, which is maybe easier time than being in the Rice jail at this point.
Yeah.
So I think for that client, it was a good deal. I think it was a big loss, by the way, for the prosecutor, Michael.
Well, you know how they're going to spin this. The funny factor is going to say, see, we got a RICO conviction. That was our goal when we started this process. We got that RICO conviction. Now, if you drill down, as we just heard from Ms. Hilton, the murder charges, gone. The gang-related charges, gone. The gun possession charges, gone. All that's out. That's the meat. So, what they got was kind of like a hollow victory, I think.
Yeah, all the violence is out. They got 2 minor drug charges.
Yeah, so we're going to talk about that. We're going to talk about that.
2 minor drug charges. And to me, the most important thing that they did not get, and obviously did not require, that anyone who pleaded guilty, like they did in the immunity deals or the plea deals previously, testify in the trial against Jeffrey Williams that YSL is a gang. They didn't get that.
Yeah, and we're going to hear from Doug here. He talks about what he thinks the impact of this plea has on the other defendants. Remember, it is a conspiracy count to which he's pled guilty. So, you got to have a conspiracy with somebody, somewhere. Something had to have happened.
Right, and yes, the judge, by the way, did know. This is one of our questions. Did know that the plea was being accepted. Remind you, by the way, that the plea was to drug charges that he had pled guilty to previously.
Yeah, one was in June and one was in October. I think both in 2022. I think, but yeah, they were effectively already adjudicated.
Right.
And so really, it was a matter of figuring out what the penalty was going to be. And as well as I do, Linda, you wonder, what's the judge going to do? Is the judge going to reject? The judge is kind of sort of in on the mix here. It's not like this is out of the blue for her. She's anticipating what's coming. And it would have been a shocker for her to say, no, I don't like it.
Yep. Yeah. Yes, you're right. Mr. Harvey, great attorney there, made it sure he's only accepted the 2 drug charges.
That's right.
And we're going to talk about that because
let's get
there was
into
a
that.
little bit. So, Michael,
let's get into that. And the first thing that I want to show is Miss Hilton. Again, remember what she's trying to do here. This is illustrative for many reasons. It gives you a very tight version of their story. But specifically, as it relates to this plea agreement and this hearing, listen to what she's trying to cram in to this plea agreement that may or may not have anything to do with what this defendant is agreeing to. Again, so this is Ms. Hilton. This is probably about 5-6 minutes, but it's such packed with such info. I think it's important.
Your Honor, if this case were to continue with trial, Your Honor, the state would expect, as to this defendant, the state would expect to show that what has already come into evidence, that on July 3rd, 2017, as well as October 23rd, 2018, that this defendant is an associate of the enterprise of YSL, also known as Young Slime Life, and that he conspired to associate together with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. In furtherance of the conspiracy, this defendant engaged in the activities below. He engaged in activities that assisted with preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity to include murder, assault, and threats of violence. That this defendant preserved, protect, and enhance the reputation, power, and territory of the enterprise by the posting of messages, images, appearance in videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf, and to obtain money, weapons, and other property through acts of racketeering activity, including the unlawful sale and distribution of drugs. Your Honor, evidence has come in during this trial that on July 3rd, 2017, Mr. Nichols was located at 2612 Steele Avenue, which is in the Cleveland Avenue sector of the city. Your Honor, he was found inside of a vehicle. When that vehicle was searched, Your Honor, this was in October 2018, they found marijuana as well as sandwich baggies that would be used to package drugs, and there are also guns found inside of that vehicle. Also in July of 2017, this defendant was stopped during a traffic stop in the Cascade area, Your Honor. After being stopped, Your Honor, there was a consensual search of the vehicle that yielded powder MDMA, Xanax, as well as a loaded gun inside of that vehicle. Additionally, Your Honor, in July of 2019, Mr. Nichols was featured in a video with another YSL member, Shannon Stillwell, and Woody Lee. In that video, it was entitled Slap Talk. And in that video, co-conspirator Shannon Stillwell, while performing, makes such quotes as, "Me and my slimes are above the law." We know from the evidence that slimes is one of the terminology used by members of YSL to refer to themselves or other members of this enterprise. And then last but certainly not least, Your Honor, that in March of 2022, Your Honor, Mr. Nichols was found in surveillance video at a gas station at Windsor Street and Fulton Street here in Atlanta, Georgia. This was on March 14, 2022, during what the state would believe to show an onset of a gang war that really started in 2015 with the death of Donovan Thomas, but carried on into 2022. In February of 2022, a rival gang member by the name of Rayshawn Bennett, also known as YFN Lucci, was stabbed at the Fulton County Jail in February of 2022. Information about that stabbing was made public at early part of March 2022, around March 3rd of 2022. Once that information was released to the public, there was an onset of retaliatory activity that occurred between March 3rd, 2022 and March 16th of 2022. That includes a March 11th homicide of YSL associates.
Now, let me just stop for a second. All this is totally irrelevant. All of this stuff about subsequent meetings and a murder here, and it has nothing to do with this plea deal.
McMiller and Darius Ford. It also did include a retaliatory shooting of a YFN associate, and then ultimately it led to a murder of Shamel Drinks, who we believe is a YFN associate. This murder occurred again on March 14, 2022. Mr. Nichols is seen on surveillance video at that BP gas station, as I just referenced earlier. he was at the gas station with YSL co-conspirator Shannon Stillwell. Mr. Stillwell was driving an Audi vehicle. Mr. Nichols came to that gas station in a Ford Fusion vehicle. You see both of them on camera together. While they are at that gas station, Shamel Drinks approaches that gas station as well. I think unbeknownst to Mr. Drinks, Mr. Stillwell was still in his vehicle, which is the Audi. At some point in time, Mr. Nichols got to his vehicle, the Ford Fusion. Once Mr. Drinks finished his business or finished handling business at that gas station, we know that there's a phone call between occupants of the car that Mr. Stillwell was in and occupants of the car that Mr. Nichols was in. That communication was to the effect of, you need to get on FaceTime. As soon as that conversation ensues, we see Mr. Drinks leave the gas station in his vehicle, and both the car that Mr. Stillwell is driving as well as the car that Mr. Nichols is driving both follow out of the gas station, following behind Mr. Drinks. Mr. Drinks proceeds down the street to the light at Windsor, which is right by I-20 in Windsor. Mr. Drinks is in the far left lane. The car involving with Mr. Stillwell pulls up to the middle lane, and Mr. Nichols' vehicle pulls up to the far right lane. This is all captured on surveillance video and surveillance camera. They are at the light for a moment. Then we see both this car with Mr. Stillwell as well as the car with Mr. Nichols drive through a red light, leaving the car with Mr. Drinks sitting at that light. About 30 minutes later, a Good Samaritan sees that car still sitting there, approaches the vehicle, and Mr. Drinks is now deceased.
Okay, that's a lot of death and destruction for two drug-related charges. So,
Right, and that's the
Samantha.
sort of,
Is that Samantha? Yes, Samantha is correct. Maybe there is a death that they're mourning with the
but
outfit.
that's the case, Michael. That is the case they wanted to have. It's
Yes,
not the case
yes.
that it's been
I
presented.
feel like it's reading a child's book, and that's the story. Good night, you know.
Quamarvius Nichols pled guilty to 2 drug deals that he had pleaded guilty to in the past. I mean, it didn't take 152 trial days to get here. But remember, he was the one that his attorney the other day, it wasn't Bruce Harvey who was in the courtroom then, asked for the mistrial motion when that free quay came up in the courtroom that was read. And the judge asked his attorney at that point, do you want a mistrial motion? Do you want a mistrial? She said,
Yes. Yeah. That was Nicole Westmoreland. He has
Yeah.
three attorneys,
Right.
and she was the one in charge that day. And be careful what you wish for. I think this worked out much better for their client.
Yeah.
Okay. So one last
what's
clip.
next?
This is basically his attorney, Mr. Harvey, saying, "Whoa, hold on. Interesting storytelling. Very interesting." But not related to what we're doing here. So this is so smart for this guy to, he's doing his job. He's a good lawyer. And his job is to make sure the record is clear as to what they're acknowledging, what they are pleading guilty to, and most importantly, what they're not pleading guilty to.
He's also
Okay,
a great
are
dandy.
y'all acknowledging a factual basis to the count 1, the RICO count?
Okay, we are acknowledging a factual basis. There has already been evidence with regard to the July 3rd, 2017 drug event, the October 23rd, 2018 drug event. We categorically deny and contest any use of violence by Mr. Nichols. We don't agree to that underlying factual basis. We believe those 2 predicate acts that were committed by Mr. Nichols without any question are sufficient to meet the elements of the offense. The offense to which he's pleaded to, which is a RICO conspiracy. A RICO conspiracy requires proof that the defendant either conspire with another person to violate one of the substantive provisions of RICO, and that would be drug offenses, or personally endeavor, I believe that's what the language of the statute says, to violate one of the substantive provisions.
Well, that's what the language of the statute says, but he
Yes.
is indicted in this indictment with conspiring, not with endeavoring.
That's correct. So we're talking about a conspiracy. We acknowledge the two events that he participated in. We categorically deny any other allegations other than those two events that are sufficient for a factual basis. We categorically deny that we participated in any way in the unfortunate death of Mr. Drinks. We categorically deny any other charges to which we are, substantive charges to which we are not entering a plea, and that includes gang charges. This is a plea solely to a conspiracy to violate the RICO Act.
What's wrong there, Miss Love? You seem a little fidgety.
Yeah, it's just
Seem
looks so good there,
little
right?
fidgety in your chair there. His attorney doing a great job of, making sure the record was cleared. Don't
It's
pin
not-
us with those other crap.
But it sounds like, they came to this deal and then they try to get one underneath
Yeah.
by reading all the factual basis for everybody that they wanted to prove and say, oh, yeah, you see this RICO? I think that was a press maneuver. I'm sorry. I think that was a press maneuver.
Because now
I don't
they
know
can
who's
say,
calling
look
it.
at us. Look at us. We got a
right.
RICO conviction.
Right.
But maybe they're also trying to make themselves look better in the big scheme of things. Look, this is the case we've got. That's either what's coming or part of what we've shown you already. It's coming.
No, it's not coming. It's on day 152. It's definitely not coming. What's coming is how many mistrial motions have been made? 50?
It's almost 50-ish. It's rounded up, rounded down. It's right around. It's right around 50.
I mean, that case is not coming.
So, and again, we have Doug coming up here to fill us in, not only on the days we missed where we're wondering, oh my gosh, what's happening, but also on what's to come, because this may or may not be the last plea deal, and maybe his client is enticed by something, maybe he's not. So before we get into that, I was ask you a question. Now I can't remember what it was. It was something about her presentation. Why do you think she was doing it and not Ms. Love?
Well, because I think Ms. Love they're trying to take her out of the limelight right now. She's caused so much heat, so much problems for this prosecution, and the judge clearly was upset with her, even though it was Hilton who made the mistake about the and for the hashtag. I think that Ms. Love is just people hate her. I think people hate her. That's exactly what it comes down to. Be honest with you,
she's unlikable.
She's unlikable. That's
unlikable.
right. And likability is important. As you know, you can, even for the jury, for the public or whatever.
Never underestimate the power of likability.
You always say that.
I
You
do.
always say that.
And so the inverse is obviously true as well. Okay, so we check in with our boy Dougie and see what he's got to say about this. Let me pull this up. I'm going to make us disappear entirely if I do this right, because who needs to see us on the side of us on the main screen? But, with me, it's a crapshoot. Let me see what I can come up with here. I really am not 100% sure. I used to do this all the time, and that's all I could do was squeeze this out of the picture. So let me see. Standing by here. If I can't do it, I'll try to minimize it.
Killing me.
And I'll try to minimize this at the very least, if I can.
Here comes Doug.
Yeah, here he comes. Yep, that's him already. Hey, welcome to Justice Served TV. Michael Bryant here, Linda Kenny Bodden. Look who has joined us.
Hey, guys.
The busiest men in Fulton County.
And I would love to say Jets green, but I'm not going to mention the team. Football.
Yeah, that's fine. You guys stumble through, I guess.
So, as usual, not much going on in the YSL case. So tell us, people were dying, from adjournment last Wednesday to today. There was all kinds of craziness going on. You were doing your best to update people on
but not saying anything
on TikTok. Yeah. Well, I've found that that's what TikTok is best for. People not saying anything. Okay. So give us what you can give us about the ramp up to today.
Yeah. So, it's fair to say that there have been plea offers made from the state over the last few days. And as you know, as lawyers, we're obligated to pass those on to our clients. And that's kind of what's been going on. And so as a result, I mean, you saw Mr. Nichols plead out today. Um, Mr. Harvey, I guess, was Ms. Westmoreland, his attorney team. They were able to negotiate a deal that I guess Mr. Nichols felt was in his best interest. And I don't know if you watched the plea colloquy that took place, but
We did.
it's kind of what I was expecting to see, which is the state vomiting forth a whole series of allegations that some of which they had some evidence for in court, a lot of which they didn't. And then you saw Mr. Harvey respond to that, which is, we're not in agreement with that. We are in agreement that there is a basis for the RICO conspiracy plea, a limited basis for it, and therefore we're taking the plea. I mean, I don't want to speak for Mr. Harvey, but nothing that Mr. Nichols pled to has any impact on my client's case.
That's correct. I had three things stuck out to me,
Yeah.
Doug. Was number one, that he pled to the most innocuous two drug offenses, right? He's
Yeah.
going to he's probably done most of his time for the 7 years if he gets some credits going on. And the third thing that stuck out, actually, the third thing was 3A and 3B, was that he wasn't required to testify against any other co-defendant in a plea. That was like, whoa, that stuck way out to me. And then the fourth thing was, and Michael tweeted about it on the Justice Serve TV, was that we thought the state was trying to pull a fast one by listing all these acts that he didn't plead to on something they didn't prove.
Well, but the state was faced with an experienced, excellent trial attorney in Bruce Harvey, who was able to stand up there and say, whoa, 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 no, 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 we're not agreeing to that. We're agreeing to these limited drug charges. And by the way, was that 3B or 4? But anyway, here's either here's either a 4A or a 5, which I don't know if you noticed this. And I thought this was huge. There were no factual acknowledgments in his plea. And those who have watched this YSL case know that the factual acknowledgments that prior co-defendants who pled out have played a huge part in this case. I mean, that served as the basis, I think, in a lot of ways, for the revocation of Mr. Sledge, was the lack of consistency between his factual acknowledgments and his Christmas 22 plea and what he said on the stand. And here with Mr. Nichols, there were no factual acknowledgments. There's no requirement to come back and testify. And even if they were to call him back to testify, what is he going to say? Because they don't have those factual acknowledgments to use as leverage when he does come back to testify. So it's a nice, clean plea that does not blow back on any of us. And neither could it blow back against my client, because my client didn't do anything. There's no acknowledgments that he could give that would impact Mr. Kendrick.
So
Yeah,
there's been a lot of
I'm sorry, go
discussion
ahead.
about the potential pleas for the different folks. Could they come up with something global? Could they come up with something that would equate to time served? Let me just ask you this: was anything presented to your guy that was enticing in any way?
Not enticing enough for us to take a plea deal.
And you guys countered?
We talked back and forth, but there was no deal to be met. I don't know if the state is watching the same trial that I'm watching,
Or that we're watching.
or rather than say the state, I mean the powers that be, the ultimate decision maker. I don't know if she's watching the same trial that I'm watching, if she's watching it at all, if she's getting accurate information as to how the state's case is going. But I see little evidence of that. So no, we were not at a point. And it would be great if you could educate your viewers on our obligations as criminal defense attorneys, that when we get a plea offer, we have to take it to our client.
Good, I'm going to write that down. Good point, because you're absolutely right. You have to.
No matter what
take
it looks
to the
like.
client, no matter
It may
what,
No
stink.
matter what it looks like.
It may stink, but you have to lay it out. Yeah.
We have to lay it out, and that does not mean that we are not fighting for our clients. And it does not mean that we think they should take a plea. And it doesn't mean we think they did anything. It means we have an ethical, professional obligation, right? The law that we essentially operate under that we have got to take that offer to our clients. And so that is what we did.
Do you expect that the power that is, which is Fonnie Willis, we keep dancing around that, is going to say, well, look at this. This was a victory. I've got a conviction for a conspiracy to commit a RICO charge with the gang YSL. I've accomplished what I've set to accomplish.
Well, I would imagine that I'm no different than you. And if we can reach a deal that is a victory for us, and she wants to get on the air and toot her horn and declare victory and go home, God bless her.
Yeah.
All I
Kind
can,
of like what we did in Vietnam as a country.
yeah, right. Declare victory and go home. Tell Putin to declare victory and go home. But, I don't care what she has to do to save face. I don't care what anyone does anywhere. All I care about is what's best for Mr. Kendrick. That is all that I care about. And if that means Madam DA Fonnie Willis gets to give a press conference and say whatever, let her do that. But she has not presented anything to us that would entice us to accept any offer. We're winning this case. I think anyone that is watching this trial from an unbiased standpoint thinks we're winning this case. And I am very happy for a jury to get this case.
So having said that, what's on tap for even for tomorrow? Because when the judge left the bench today, no clue about reconvening for any purpose. So where are we?
We can reconvene at 9 a.m. tomorrow morning.
And this is with the jury?
No, not with the jury in the
Okay.
morning. I don't know if a jury will be there later in the day. I don't know if the jury has been told to wait until the following day. I don't know. I honestly don't know.
So this would suggest that maybe there's some other stuff that in the works that would be a function of law and motion that obviously the jury would not be part of.
I am implying nothing. But we do have evidentiary issues we have to take up prior to the jury coming back. And those are evidentiary issues that many of which we may not have had to deal with if certain defendants had pled out. So yeah, we'll see what happens. There's still things in motion, I'm sure.
So
And
one more
just let me
follow-up,
just ask you, I'm sorry.
Linda, let me have one more follow-up. I'm sorry.
Okay.
So
That was
would you be surprised if there were additional plea deals?
Nothing in this case surprises me. Ever.
Good
Ever.
answer. Darn
Ever.
it.
Ever. I would not expect us to be taking a plea deal, us being Mr. Kendrick, to be taking a plea deal. I'm expecting our case to go all the way to a jury. That's kind of, as I'm sure you do, that's how we approach everything. And we're going to continue down that path.
Is there any motions? The only thing I was going to ask you in addition to that, because I think that's a great question, and Michael just asked you. But is there anything that you have to now carve out of what's been presented to the jury as a result of the plea from Quay today?
Yeah, I don't think anything from Mr. Nichols pleading out has affected our case at all. We're not really tied to him on anything. So no, I don't see anything that's happened today causing me to file any motions on behalf of Mr. Kendrick. We still have a mistrial motion out there that the judge hasn't ruled on. So at some point, she's going to have to make a ruling on that mistrial motion. Which, by the way, I think we should get with prejudice, even though Mr. Nichols is out.
And that's what I was going to say. It's interesting because it was Westmoreland, one of his attorneys, who said, "Yeah, I'll take one. I'll take a mistrial." And now, effectively, it's it's moot because of the plea deal.
Well, first of all, because
her acceptance is moot
because of the Harvey rule. That mistrial motion was joined by all of us. Of course, the Harvey rule, for your viewers, is the rule that was put in place at the very beginning of this case before we even started trial, which is a motion made by one is made by all, an objection made by one is made by all, unless we explicitly opt out. So that mistrial motion is still out there. The judge has to rule on it. I think it should be with prejudice. I think we are still impacted by what happened on the stand because, as Mr. Harvey would say, what would you say? What is gravy for the goose is gravy for the gander. I may have that wrong, but it's not good for the it's not good for the goose, good for the gander. He's always correcting us on that. Sauce. What is sauce for the goose is sauce for the gander. So
Propaganda.
the state, through Mr. Floyd, through other prosecutors, is always saying, but what my esteemed opposing counsel, meaning us, do not understand is that this is a RICO conspiracy. And this is a RICO conspiracy. So what comes in against one comes in against all. So when one of our co-defendants is harmed by something that is said on the witness stand, we are all harmed by that, as far as I'm concerned, just taking the state's position. So I think that we are still harmed by what was said about free Quay. And I think that we still have a legitimate mistrial motion in place that the judge is going to need to rule on.
Can she force on you a mistrial? Because I know our viewers had this question the other day. A mistrial without prejudice and just declare it?
I think she probably can. I don't think she would.
Okay.
And I want it with prejudice. I want it with
I would
prejudice.
too.
And
I would think, right.
I'm not going to be there first thing in the morning. Katie Hingerty is going to be there, but I'm hoping to have the opportunity to at least bring up the mistrial with prejudice issue again after I scooch down to court after my TPO hearing I have up in 8G. So, and I'm going to bring it up because I think after roughly 50 mistrial motions, go back and look at day one. Look at day one. There was a mistrial motion then because of the state making a mistake. Yet, the first of what turned out to be scores of mistakes. And how many mistakes do you have to make before you should get a mistrial with prejudice? How many mistakes are we going to let them have before we get a mistrial with prejudice?
Yeah. That's what I've said, is that if there has not been enough done to this point to grant that motion, what do you got to see? What are you waiting for?
What's it going to take? I mean, what's it going to take?
Yeah, just amazing. And you're
Yeah.
amazing. By the way, you look a little rested from
Thank you.
wherever it
Thank you.
was you were at
Thank
Disneyland.
you.
It's
I
a
was in
small
Disney with
world.
my mom. I was in Disney
so
with my
great.
mom. And I didn't get,
great.
I mean, Thursday and Friday turned into chaos, but I got some rest. So it was fine. And I got to spend time with my family. So
There
all
you
that
go.
is good.
There you
That's
go.
great.
All right,
Doug, we love
guys.
watching you all the time, and you're
Thank
also
you for
informing us.
having
And
me
we'll
on.
tell everybody about our ethical duties, and more importantly, your ethical duty to your client. That,
Yeah, get off my
he's not
back,
entertainment.
folks.
He's not.
Get off my
He's
back,
not
folks.
entertainment. Yeah, he's
I
not
got a
entertainment.
client. I got a
Yeah.
client. Okay.
Thank you.
Thank you for
Take care,
educating
bud.
everyone.
Thank
See you.
All right, then. So,
So, very interesting question, though. One thing we did not ask Doug that our viewers picked up: when the judge does get a jury back, and we don't know when that's going to be, he indicated not tomorrow. What does she tell the jury about the empty chair that was occupied by Mr. Nichols?
yeah, I mean, it's not all that unusual, when you peel off a defendant here or there. It happens. It happens in civil cases as well, where somebody, comes to a resolution before the case gets to the jury. And usually it's about as simple and vague as it could possibly be. Mr. Nichols is no longer part of this case. You're not to infer anything from that, and we're moving on. That's it. That's what I would expect.
Yeah, and on the mistrial, no, the jury gets to exit the courtroom before they make the motion for the mistrial. But we do love Doug Weinstein. So I think we just posted something about him being kind of slimy. He's not slimy.
Who did
at
that?
all.
Really?
He's well, I don't know. You tell me, whoever posted Slimestein, was that a pejorative, or was that just a loving, we love you?
Yeah.
We're going to take it as we
Nickname.
love it. We're going to take it as we love you, because he's really, really a terrific, a great lawyer. And he did not start as a criminal defense lawyer, but he has become one of the most well-known and very effective for his client, both in court and out of court, I think.
Let's hit some of these, Disney tells us.
Oh, it's a compliment like Barbie. Oh my God. Wait a second. Wait, I have to go. It's a compliment. So I'm saying like Barbie. I didn't know if it was a compliment or a pejorative. Thank you for educating me. I had to do it
I never
because
saw that.
Well, Michael Bryan would know what it be. He
I don't
hated
see-
Barbie. He hated the
No,
movie Barbie.
No, it was horrible.
I
Brutal.
mean, wait a second.
Brutal. Didn't make it through. So
Oh, I
maybe
don't have my
someday.
Barbies. I don't have my. Well, I do
Okay,
have
so
my
I'm going to
Barbies
hit some of
up
these
here.
questions that Diz keeps yelling at us about. Princess, I'm going to say Waku. This has to do with the reference, I think, to Ms. Hilton and her recitation. It doesn't mean it's good evidence. Most is social media posts with a variety of rap lyrics as captions and private messages proven to be misrepresented. Yeah, it's thin. It's very thin. But yeah, they're relying so much on the lyrics. I mean, if that to me is not your little corroborative to tons of other evidence, what do you got? It's just pathetic, I think. And I keep waiting for something more substantive. Haven't seen it.
Yeah, someone says, Raynette, 13 years probation for Nichols. That's an ouch. But, I guess he figured, hey, maybe what we see sometimes is you serve a terrific time, like 3 to 4 years of probation, and then your lawyer comes in to move to dismiss the rest of the probationary sentence. And the judge says, you've been wonderful. Yes, we're going to cut it off right here. And is when you want to get out of jail,
Yeah.
you've got some pretty big, things that you'll do. When people plead guilty to murder, murder to avoid death penalty, think about that, because the whole justice system can be so, what's the word I'm looking for? Tough? Tough is not quite the word I'm looking for.
And just imagine if you're thinking, I can do that probation time. That's going to be no big deal. And there's also, I think, some gambler in them. Like, yeah, I'm going to be on probation, but what does that really mean? How constricted am I really going to be? I just think the overwhelming belief that I'm walking out of jail overrides the reality of probation, because I think probation can be very restrictive.
Right.
But if you're looking to get out of jail, by comparison, it's a piece of cake. Okay, here's something from Ocean Beach.
Right.
Ocean Beach. Actually, the victims' families were there. The deceased guy's aunt and mom. They hate the prosecution. I heard an interview from the aunt that said Love and Hilton have done nothing but lie to them. And you know how important it is for the prosecution to be in sync with victim family members and others that have survived whatever the crime alleged. So it's inexcusable not to be. That's just not surprising in this case, but it's inexcusable.
Right. Well, it's just the justice system minus justice is just the system, and the system needs I think this case has pointed a lot about how the system needs to be changed. But we know that you go to the Innocence Project, how many people just at the Innocence Project in New York, the national one, were like, minutes away from getting the death penalty, and turns out they were innocent. I mean, we know the system, everyone
it's
wants
not
to be tough on
perfect.
crime,
It is not perfect.
Right. It's not perfect.
I still tend to believe it's the best system on the planet, but no, it ain't perfect. And
yes, yeah, that's right.
that's okay. So this is Gemini Rising. Does the plea hurt or help the defense? Well, according to Doug, it's kind of a non-issue. What do you think?
Yeah, I think it's a non-issue
because of the crimes, right? Because of the crimes to which he pled.
He pled to marijuana. I think they're both marijuana crimes.
Yeah, you heard Miss Hilton pounding away on the enterprise as it relates to the RICO charge, and that's appropriate. That's the definition of the organization that you're part of. And she just goes on and on, just trying to pound that in, or the enterprise, all these things that were done, the enterprise. I don't know if that splashes over on anybody or not.
No.
Not as I see it right now.
The gun charge, as Ocean Beach points out, the gun charge and the murder charge are gone.
They're gone.
They're gone. So why do they indict him for it? Nobody, thank you. I'm sorry, Michael. I got distracted by DeShante Abercrombie, who said she's like me since my commentary on Trayvon Martin. So thank you very much. Because I see there's still somebody here who doesn't like me. Then why are you watching? But that's beside the point. But let's go back to the important thing. Doug Weinstein in this case.
Let's see.
Either that or I'm going to get my Barbie stuff to show you that I really all love Barbie.
Will judge consider a bond? This is another situation where Paige Whitaker, and I should apologize now. I've called her Paige Whitney a couple of times, both in like on our community tab with a poll. I used to date somebody named Paige Whitney, and so that has kind of derailed me a couple of times from Paige Whitaker, and Paige Whitney. It did not end well. So anyway, and probably why? Why did it not end well? Oh, well, jerk. That's why it didn't end well. Anyway, so we're talking about the judge. We know that she inherited the no bond position from Glanville, and there's been this total deference to things that he's decided before he was recused. And, I think if it were a part of a negotiated deal, we talked about this yesterday, if bond was part of the deal that they crafted for one of the defendants, then I think she'd go along with it. But I don't think in and of itself, anybody's going to reapply for bond and see any different result than we've seen all along.
Oh, thank you. Yes, thank you very much for the belated birthday wishes. I appreciate it very much. Someone let the cat out of the bag. I don't know who that was, Michael.
Let's see. This is
I
interesting.
just love you all for watching us and all, because I think you all bring up such great points. Yes, remember, someone mentioned the case Robertson in Texas. He was
the shaken baby case,
the shaken
or the
baby
no
case.
shaken baby case.
No case, shaken baby. That's still going on. I'm still caught up in the fact that this case evidence is what's so wrong with the system. Even the fact that Quay had to take a plea to 2 marijuana charges that he pled guilty to that now have a RICO conviction. I can't wrap my head around it, Michael.
Yeah. Again, is that part of the show trial? Probably, because the DA wants to claim some level of victory, and it's, like I said, I think it's hollow. Okay, so let's see. What was that one that I popped up here? Does no one trust the jury? Oh, well, when you're faced with that, what if, a jury can do anything. We know that, even though we've seen this case unfold as, a bad case, a joke. That doesn't mean the jury is going to feel that way. You have no idea what a jury is going to do. So those are the dice that you're rolling. I can get this relatively minor sentence, all things considered, even with a longer probation at the end. Or, this guy's, you heard Hilton rattle off the different charges under the indictment for Mr. Nichols. You might get a calculator because you're talking about the end of his life in prison. So when you start weighing that, it's less about trusting the jury than it is chancing your life with the jury. And I don't know that anybody feels comfortable doing that.
No, and that's always the problem. It's a roll of the dice, no matter how good you are. I mean, when you have that case and there's nothing more you can do, the judge has charged that jury and you're waiting for that jury verdict. You know that you should have a not guilty, but you never know. It's to go 7 days and they're not back, and they're saying, what are they discussing?
And then you start
in
wondering,
there?
maybe I should have taken that deal.
Yeah. Now, was she granted mistrial? Somebody asked, and I had posted it and went by. Do you think the judge is going to grant a mistrial? What do you think, Michael?
I think, first of all, she will not grant one with prejudice, which means nobody's going to accept that, in my opinion. Nobody's going to take a mistrial with a redo. It's not going to happen.
But Doug said that she can force it.
Well, yeah. So I don't think she's going to just sua sponte say, that's it. How you normally would handle a hung jury. That's the natural result of the hung jury. That's a mistrial without prejudice. That's forced upon the parties. There's no discussion. There's no arguing for or against. We've seen it in the Karen Reed case, which is coming up again for trial in January. But I don't think she's going to force it on anybody. I think she may still offer it to anybody who wants one without prejudice. And I don't think anybody will take one. So what does that mean? Unless they come to a deal, and you heard Doug, possible. Might be some other deals in the ether, not for his client, not for Yak Gotti, which was kind of an exclusive tidbit that we learned. I'm surprised that he was quite that forthright about that. But there may be others, and if there ain't, then we're going to a verdict.
Yeah, it doesn't sound like it'd be for Jeffrey Williams because either.
No, and he is less motivated because he's clean.
Right. So we'll have to see. That only leaves 2 more that are in the courtroom, and we'll have to see if something happens tomorrow. And then there'll be 3 that will go to a jury verdict or mistrial motion 574. I mean, I'm making that up, but
at some point,
at some point, and Doug points out on day 1 there was a mistrial motion. On day 1 of this trial, there was a mistrial motion. And here we are, 50 some mistrial motions later, or about 50 mistrial motions later, if you're counting.
Email Gerard, good question. These are, when you have a plea deal, that you're done. They aren't going to come back to haunt you. You have appellate rights, as the judge mentioned, both for habeas corpus and attacks on other elements of the plea deal. But no, they can't say, hey, we changed our mind. We're going to bring back those charges. They are truly, in the firmest way, with prejudice.
Yep. Yeah, and the judge made it clear that if he wants to retract this plea, that probably won't happen, although he does have a certain time to do that. but he does maintain the rights for it to talk about the constitutionality of the plea, and that means the constitutionality of the statute, I think, Michael.
Yeah, I think it is. It's a very esoteric kind of legal argument. So, she's just making the record clear that you still have that opportunity. Here's a good question. Hey, Camille Miley, where were you when we were interviewing Doug? Because we didn't ask him about the sloppiness. People have talked about it's not the judge's job to clean up the prosecution's mess, but in fact, that's what she's doing, and she's admitted to doing it. So next time we talk to Doug, we'll definitely ask him about that.
That's a great question.
It is. I get the feeling it's going to be an ongoing issue.
Yeah.
Clean up on aisle 7.
Okay. That was from what? Is that something going out of business?
There's actually 2 aisles in this courtroom, so and most of them seem to be on the first aisle.
Thank you.
Oh, whoops! I just got rid of that. I missed that. What was that? Put that back up, Diz.
I wish y'all would go live on the trial streaming. I love the channel. Thank you for the insider scoop over the channel has access to. Well, we try, but we also have sources that we also don't disclose, because we're trying to function here as reporter journalists, not as lawyer friends, but L.A. Stony Stone. Is that what that is? Is that
I'm going to go with Law Stony Stone, but it may be Law L.A.
LA Stony Stone.
Okay.
Yeah, we're working. We're young. We started this to try to do some politics and some other stuff when Law and Crime was on the air. When Law and Crime decided they didn't want hosts commenting on anything, Michael and I, after Labor Day, decided to really focus on this channel along with our law practices, which means we get no sleep. But we think that the viewers are important, because if you don't know what's going on in the courtroom, when we get up there in the one trial that you do see, you're going to say, hey, wait a second, everyone's guilty. But when you see all this stuff, right, that maybe all defense lawyers aren't so bad. Now, some of them, even I don't think are so great. And I'm a defense lawyer, but I'm a former prosecutor too. So I call it as I see it.
We were just talking about this. YSL call each other slime. King slime is allegedly Jeffrey Williams. Yes. So it's a term of endearment if it's used properly. So you can be slimed and actually it's a good thing. Let me see. I'm just scrolling through here because Diz has told me we keep missing some of these ones that have been starred. How am I doing? Are we good, Diz? I think I'm good. I think I've caught up with all of them. Oh,
well, there's so many of them. I don't know if we can answer all of them, but we're going to try.
We will try. Okay, crazy day. I think tomorrow may hold other surprises, but what else is new? It's YSL, right?
Yeah, and we're going to be on the air again tomorrow night. I think we haven't set a time whether it's 5.
Yeah, I thought we were going to try and do 6, but it will be. What we're doing is we're moving our normal Q&A from the afternoon to the evening. Why? By popular demand and request. We ask you guys, but what's better for you guys? And yeah, we can be a little bit fluid, but if later in the day is better, then we'll try and shoot for later in the day, and then tomorrow we may have an update on this mess.
Right, and we may have Doug back on depending on what happens tomorrow. I just will tell you we are trying to also get Ashley Merchant on, maybe her husband on, and then at some point, since I actually lectured before the criminal defense attorneys a few years back with the Innocence Project people, we may want to try to get a panel on to discuss this whole case in Georgia and Fonnie Willis, because remember, in a week there's election. The likelihood is she's going to be reelected, the DA of this county, and you have this case going on, you have the Trump case going on, you have the Open Public Records Act case going on. There's a lot going on, and we haven't forgotten about Dexter Q. Bond or who was the guy who she appointed as a special prosecutor? Oh, Mr. Wade. How could I forget his name?
Oh, yes. Once she, once Ashley confirms she's got all those documents, who knows what we're going to find and what the numbers will lead to. We believe there's been a misappropriation of taxpayer dollars that were given to Mr. Wade.
Okay, now let me know what you're saying that LTO, let me just tell you, we haven't taken calls, but what we are doing right now, because again, we're still trying to get this up and running to answer for you. And sometimes we have 30,000 views on an episode. Sometimes we have 150 views on an episode. But what we are doing is asking, and if you'd like to, send Dizzy, send to us in our X account or email Michael Bryant. We'd like to have at least 2 of you who are viewers on to ask your questions live. We did that last week. And you came on the air. We gave you the link. We put you in the green room here. We brought you out. You were on the show. and you asked your questions live, and then it became part of the conversation. So if you want to do that, LTO, you have to be seen on camera. You know, we can't dot you out like they do in some cases. We'd love to have you do it and ask your question live.
Yeah, and we may at some point do like a phone-in call. Take me back to my radio talk show days. Those are the good old days.
We're getting there. We're getting there.
We can do that. It's technologically it's easy. So we just have to figure out where we are and what we're doing. But we appreciate that.
I think trying a murder case technologically is easy, but you know, this is a whole different thing for me.
Okay. All right then. I think that's going to wrap it up. So as I do like to say, try to do the right thing.
And I'm going to say subscribe, like, share, and notify on this channel